Well, the session this week is about justice reporting, which covers three separate main beats in journalism: crime, courts, and prison. The text covers crime reporting under Chapter 10, a larger category of public safety and disaster reporting, and Chapter 11 in the text is on covering courts. You can see that the background for me today is a photo of a typical courtroom in BC. If you look at the photo, maybe I'll get out of the way. I'll get out of the way so you can see. So what you see in this picture is you see in the front part. The front part is the public gallery. You see a barrier, and you see a doorway through the barrier. Usually there's a swing gate. When you go into a courtroom in BC, you can sit in this public gallery. You can't pass beyond the low wall there while they're sitting. You see next. You see two tables, one on the left, one on the right. The one on the right is where the Crown Prosecutor sits, always in the same place, on the right. On the left, the defense attorney. Next, you see a low desk. That's where the court clerks sit. And at the back, you see a high seat, and that's where the judge sits. On the left, you see a plexiglass box, and that's typically for the accused. So this is the kind of courtroom you would see in BC, the kind of courtroom you'd see in Kamloops. If you want to know what's happening in Kamloops Court today, now that all that information is online, I put the links on Moodle. I just checked this morning. Today there's a continuation of a trial, a 4-week trial of a man accused in a gang-related murder in Kamloops that happened in 2019 in Brocklehurst. This is the first, it's a jury trial, and this is the first jury trial in Kamloops since the COVID started. I was reading the article online about the trial this morning in Kamloops this week. It was written by a former student of mine who took this course and is now covering, he's now covering courts beyond all sorts of things. Let me start by saying that justice reporting is an ideological minefield. Now, what do I mean by that? I mean that everybody you encounter in terms of crime and justice issues has an ideology, has a theory to explain what causes crime and what fixes crime, what is fair and what is unfair. So any interview comes in the context of that person's ideology about crime. The ideologies about justice issues are so deep and so personal in people, and their beliefs are so strong that they often don't realize they have an ideology. They just think that others are crazy when it comes to understanding justice issue. Everybody thinks their view of justice issues is the reality. If you take a global view, different countries and different cultures have a different sense of what is fair and what is unfair, what causes crime and what fixes crime. Sometime in this course, I'm hoping to find time to play a new PBS documentary that's available on YouTube called 1,000 Cuts. It's about the Filipina journalist Maria Ressa, who's been sentenced to prison over what some believe are trumped-up charges to intimidate the media in that country. The current president in the Philippines, Rodrigo Duterte, says he is fighting a war against drugs and allowing extrajudicial killings of those involved with drugs. That is a right-wing ideology that people who use drugs, including marijuana, which is legal in Canada, are criminals who should be exterminated without even going through a trial. Thousands of people have been killed in the Philippines in this war on drugs without being given a trial, and yet Duterte is very popular as a leader in the country. When I was on the prison beat and worked in my spare time as a volunteer prisoner escort, I was escorting Canada's longest-serving marijuana offender from prison to the local cable TV station, where once a week he hosted a cable TV show called Prison Life TV. His name is Rosie Rowbottom, and he was sentenced in 1977 to 19 years in prison just for marijuana offenses. No hard drugs, no violent crime, just marijuana, 19 years. The day that the sentence ended for Rosie, I picked him up at the prison. I took him to have his first breakfast as a free man, and then I put him on the train to Toronto, and then went back to the newsroom to write the story that Canada's longest-serving marijuana offender was finally out of prison. Right away, Rosie landed a job with CBC and was on the air reporting about crime and prisons. And he may have got that job with the CBC because of his cable TV show while still in prison. The point is that ideas about justice are usually ideas from an ideology. Possessing and selling marijuana was once a crime in Canada. It's no longer a crime. But in the Philippines, you can be shot by the police without trial over marijuana. Society changes. What was once a crime may no longer be a crime. For example, the writer Oscar Wilde in England was once put in prison for being gay. New crimes emerge. Now we have data theft, cyber crimes, and cyber stalking. So ideology changes and ideology divides. And if you're going to cover justice issues, you will encounter ideology. The different branches of the justice system, police, courts, and prisons, each come with their own ideologies, and these branches of the justice system break into subgroups. For example, in the court system, judges, prosecutors, and defense attorneys, and each of those have their own ideological view. And each of these subgroups have their own ideological subgroups. For example, a judge can be conservative or liberal on a spectrum of degrees of being conservative or liberal. The ideology of judge becomes an issue when appointing a judge to be a Supreme Court judge. Supreme Court judges rule at the highest level of the law in the country, such as interpreting the Constitution legally, and in the process of interpretation, refining and redefining the highest level of law or changing it. For that reason, the appointment of judges to the Supreme Court becomes a political battle. Liberal politicians want to appoint liberal judges, and conservative politicians want to appoint conservative judges because they want either liberal or conservative interpretations of the Constitution and of the highest laws of the land. That is why there was such a political battle in the United States just at the end of 2020, when Donald Trump failed to be re-elected president for a second term, but he and the Republicans wanted to appoint a Republican replacement judge in the time between the election and when Joe Biden would take office. But even at a local level, a judge may have a record of making liberal or conservative decisions, and the defense lawyers know the ideology of the judge before going into court, and they adapt their case to that. So, as a journalist reporting on justice issues, you have to understand the ideology, including the ideology of your media outlet and the ideology of the editor who is supervising you and the ideology of your audience. It is an uncomfortable situation for you when your personal ideology is at odds with your editors and your audience. I remember that when I was on the court beat, the city editor changed from an editor born in Hong Kong who was very practical and down to earth to a sports editor appointed to be city editor who was right-wing. And I remember him saying to me one day, quote, "They should lock them up and throw away the key," end quote. That was a right-wing ideology that saw people who break the law as deviants who deserve hard treatment and punishment. And you will hear that same ideology as in right-wing politicians who talk about getting tough on crime, expanding the police force, and giving longer sentences for crime. And those right-wing politicians appeal to right-wing voters in society. I remember one time on the court beat when the right-wing city editor had a tip that somebody who had been convicted by a specific judge, and the tip was that the judge was corrupt. Now, the chances that this tip would lead somewhere were less than nil. Proving that a judge is corrupt would be an immense piece of investigative work and would run the risk of a huge libel case. And I knew that from my experience. But the city editor was the city editor, and he hated to be contradicted, so I wasted a whole day checking out a false story. I knew that I was getting paid to do what the city editor wanted, even if it was senseless. In spite of, in that particular newsroom, in my experience of that newsroom, in spite of having a right-wing editor, the dynamic of this newsroom was that the editing desk was liberal and at odds with the city editor. And you always got to consider the dynamics of the newsroom. That's something that your audience doesn't see. It's a reality as a journalist that you have to deal with, the dynamics of your newsroom. In this case, the editing desk had all the power of editing, and each editor was different. So the city editor could assign stories, but the editing desk would then guide the stories through the editing process. And in a sense, at that point, the city editor was out of the loop. In this newsroom, because of drastic cutbacks in staff, 1/3 of the editors were fired in one day to save money. And so when I was on the court beat, I ended up being edited by an editor whose only experience was editing book reviews. And for that reason, she rarely changed what I wrote, although some headlines in my stories written by the editor were legally wrong, and that was embarrassing for me because most people assume that a reporter writes the headlines and edits the story, and they think that the mistakes are yours. It's part of the dynamics, part of the life behind the scene. In Kamloops, the next federal election will be interesting because the conservative incumbent is stepping down and a Crown prosecutor is seeking the conservative nomination. The NDP nomination is being sought by a lawyer who is once a judge. So that next federal election in Kamloops could be interesting in terms of justice issues if these two candidates get the nominations from the party. Different media outlets have different ideologies for justice issues. So readers can choose the media outlet that suits their ideology. And like I said, the ideologies about justice issues are so deep and so personal in people, and their beliefs so strong that they don't often realize they have an ideology. Everybody thinks their view of justice is the reality. And because the beliefs are deep and personal, if you argue with them, they can get angry. So what kind of ideologies are there in justice and crime stories? Laws in a country are written in an ideological context, and different countries pass different laws based on different ideologies, where a crime in one country is not a crime in another country, or a crime at one time in history is not a crime in another time in history. Thus, Oscar Wilde goes to prison for being gay, and Rosie Rowbottom goes to prison in Canada for marijuana offenses. Now, once it was legal to have slaves, once racism and racial segregation were legal, once children in Canada were thrown into the adult federal prison for minor crimes like stealing a loaf of bread or picking pockets on a steamboat. That happened in the 1880s, and I know historically about these cases. In some countries, there are crimes based on religious beliefs. In some countries, it is illegal to have alcohol, and you still find that in places around the world. An important distinction in deciding in the justice system whether someone is guilty of a crime is whether doing the act is by nature a crime, or is by definition a crime, or whether there's a distinction between acting rationally with free will and being under the control of other forces. And that's typically the situation for a court system in a country like Canada. The court case, in very general terms, will be making a distinction whether the accused acted rationally with under free will, or whether the accused was under the control of other forces. So we look at situations to test the ideology of crime. For example, is the killing of a living, thinking being always a crime? Or is it sometimes not a crime? What about killing someone in self-defense? Is that a crime or not a crime? What about a soldier killing an enemy soldier? Is that a crime or not a crime? What about a soldier killing enemy prisoners? Is that a crime or not a crime? And what about killing a living, thinking being, like a human slave or chimpanzee? In each of these examples, society has made judgments on crime based on ideology. Thus, a soldier can kill another soldier in battle. That's legal. But it is a war crime for a soldier to kill an enemy prisoner when that enemy prisoner is detained. What's the difference? How has society made those distinctions so that killing in some situations is justified, and in other cases it's not justified? Does the justice system criminalize behavior, or does it enforce the fashions and beliefs of one part of society against another society? For example, is it a crime to be mentally ill, or is it a crime to have an addiction? In other words, is there a point where a human being is under the control of other forces and can't act rationally with free will? Some countries say yes, and some countries say no. Is somebody guilty of a crime if he or she has been indoctrinated and brainwashed? For example, suppose a child grows up in a culture of violence and is indoctrinated and brainwashed into that violence for his or her full life. Is that person then acting rationally according to free will? When I say that, I actually remember a story I wrote as a journalist of a man who'd gotten out of prison in Canada after he had attempted to assassinate a foreign ambassador in Canada. And the interview was interesting because the man fit into this situation. That is one of those places in the world where children 14 years old are carrying assault rifles, and they're indoctrinated in that culture and violence, and that's what happened in this man's life. Why are things like prostitution, smoking marijuana, and not conforming to state religious beliefs a crime in one part of the world and not a crime in another part of the world? How can crime be geographical? That is, the nature of crime changes when you cross the border from one country to another country, from one province to another province, from one U.S. state to another U.S. state. Is vagrancy or homelessness a crime? Is looking at photos a crime? Is what you do in the privacy of your home a crime? Are alcoholism and drug addiction a crime? If you hurt someone or commit a crime because of alcoholism or drug addiction, is that a criminal action? Is selling food with trans fats a crime? There have been times when certain jurisdictions have outlawed trans fats because they're considered bad for people's health. Is selling food with trans fat a crime? Is it a crime to criticize the government and not accept the government's point of view? In some countries it is. That's why there are gulags. In China, lagoi. That's why there are political prisoners. In Canada, at one time in 1835, a newspaper editor in Nova Scotia was put on trial for criticizing the government. Is it a crime to defy a law that takes away your rights when there is no violence or physical harm, such as the right to bargain for a contract, the right to strike? And in some cases, a government will decide that a service is essential and that the right to strike should be taken away. That happened in the case of teachers in British Columbia a few years ago. The point is that a crime to defy a law like that takes away your rights when there is no violence or physical harm? How far can you defend your views without coming into conflict with the law? When does a protest become illegal? And right now we've just got an instance of that happening in Hong Kong, happening in Myanmar, where there's been a coup by the military, and the protesters are being assaulted by the police. The sentencing for the conviction of crime is written into the law, and that is also ideological. On a simple level, is based on someone needs to be punished, needs to be deterred from future crime, or needs to be rehabilitated. If punishment, what is the appropriate punishment? For example, if a person is convicted of being a thief, is it fair punishment to cut off his hands? Certainly, the person won't be able to steal anything in the future without his hands, and that's a simple and effective solution and deterrent. What if somebody kills someone else? Should the person be executed for taking a life? And the concept of one life for another life. If murder is a crime, why can soldiers kill others in a war? If somebody is automatically executed for killing someone, will that actually deter others? Actually, evidence is that deterrence does not work well. Criminals don't usually feel deterred because their actions are often impulsive and they are optimistic that they won't get caught. Some countries like Canada don't believe that the death penalty is a solution. The death penalty was abolished in Canada in the Criminal Code in 1976, and the death penalty for military offenses in Canada under the National Defense Act was abolished in 1999. So there's no death penalty in Canada. But in the United States, just across the border, some states have the death penalty and others don't. So the sentence varies from state to state. You can commit the same crime in one state in the United States and get one type of punishment. You can cross the border to another state, commit the same crime, and get a different form of punishment. What if a woman kills her husband after he has been assaulting her for years? She's killed someone, so should she be convicted of murder? The justice system in Canada developed what is called the battered wife syndrome as a defense in a murder trial. It's a version of a self-defense, a special self-defense defense, and this originated from a case of a killing in 1986. What the battered wife syndrome defense means that is that even if a wife is not being attacked at a specific moment, she is acting in self-defense in an ongoing situation. When I was a court reporter, I covered a case that set a new precedent in the law in Canada by applying the battered wife defense into new circumstances. The case had to do with a prisoner who murdered another prisoner. The defense lawyer argued that the situation was analogous to the battered wife defense because the accused was locked in a prison with a prisoner who was repeatedly assaulting him. The defense lawyer called it battered prisoner syndrome. The judge found the defendant not guilty, and that created a new defense. And since I was a court reporter in Kingston, Ontario, which is the prison capital of Canada, with 8 federal prisons at that time, I would see cases from the prison coming through the court system. So what causes crime and what prevents crime? And like I said, there's different ideologies about this. The ideology of justice has to do with the theory of what causes crime and what prevents crime. The basic form of this causal principle is whether an individual is wholly responsible for a crime that he or she commits, or do outside factors cause a person to commit crime. Where does the responsibility for the crime lie? For example, when a person is inebriated with alcohol and drugs and causes a car accident because the person is unable to drive properly, was that accident caused by the person or caused by the inebriation? The current position of the justice system in Canada is that an individual makes the choice to become inebriated, and because the person makes that choice, the person is responsible for what happens while he or she is inebriated. But what if a person has a mental disorder and commits a crime? Is the responsibility for that crime the person or the mental disorder? And a person with a mental disorder able to make a free, rational choice? I mentioned last time taking this class to see the opening of a trial of a man who in 2008 murdered his 3 stepchildren. The evidence at the trial in 2010 was that this man was schizophrenic, his actions were irrational, that he was basically not able to make rational decisions by his own free will, and he was found not guilty by reason of insanity. When you're found not guilty of reason of insanity, it doesn't mean you walk out of the courtroom a free person. This person was typically then sent to a psychiatric hospital. And there was a story in the Vancouver Sun in March of 2020 that talked about him getting an unescorted passes into the community. That means he's still in the psychiatric hospital, but they're allowing him to, or making the decision that he can go out on temporary passes and then come back. In this case, in this trial that I've just cited in Kamloops, the justice system decided that the mental disorder was responsible for the crime and the individual did not have rational free will to make a choice. But you could have, hypothetically, a justice system built on the belief that every individual always has rational free choice and is always responsible for his or her action. So I spent some time talking about ideology in the justice system and various manifestations of that ideology, and that's something you have to deal with. And like I said, you will encounter ideology in the media outlet you'll work for. You'll encounter ideology in amongst the editors. You'll encounter ideology in your audience, and ideology of like this that has to do with justice and fairness. It's difficult for people not to have strong personal convictions. So that presents a problem for you as a journalist. Aren't reporters supposed to be neutral in what they write, not taking sides and not expressing their personal views and their personal ideology? And that's the conventional view of ethical, responsible journalism, but practically not every journalist or every media outlet is ethical and responsible. Nevertheless, you can strive for that ideal. So how do you do that as a journalist? How do you discipline yourself in your writing? And the tips I'm going to give now would apply to anything you do in journalism. It doesn't just have to be the justice system, and something that you should be attempting in the news assignment in this course, to practice the discipline of writing as a responsible, ethical journalist. How do you do that? And particularly in this context, when I said that you can't escape from ideology, and you're going to have your own ideology as well. Well, how do you do that? Well, you are disciplined. You are a rational person with free will. You can make choices. You can discipline yourself. You can decide as a journalist what to write and what not to write. You can control how you write. That's what comes from consciousness and rationality. That's how you develop a discipline of writing a certain way. So first of all, you write the facts of what happened, and for opinions and interpretation of what happened, you quote those with the relevant knowledge and expertise to comment. To do that, you need to be able to distinguish between fact and opinion. And that seems to be a lost art in our society. People think that their beliefs and convictions are fact just because they believe them. As a journalist, you need to distinguish between what is a fact and what is an opinion, and make sure that distinction is clear in what you write. And you want to practice that discipline when you're doing the assignment in this course. That is why attribution is important in journalism, or what is called in academic language the citation. In journalism, attribute everything to a source. And that's how you discipline yourself to make your writing neutral and try to scrub your own ideology out of the story as much as you can. So attribute everything that is an opinion to a source, unless something is a universally attributed fact. You are not giving your opinion in the news story that something happened. You are saying a source says that something happened. Use a simple attribution style, such as phrases like according to, or a verb like said, a simple verb like said. In journalism style, you use the simple verb said over and over again. If there is some doubt about what a person says, you can signify doubt in your story by using the word claims. Now, you only use the word claims when there is justified doubt. Otherwise, you would be calling into question what somebody says. In a court trial, you use the verb testified to indicate the circumstances. That does not mean that what the person said in court is true. There's sometimes false and contradictory testimony in a court case. And it is the job of the judge or the jury to decide which testimony is true, not the journalist. So during the trial, you attribute what is said to a witness in court using the verb testified. Now, if attribution sounds simple, there's a catch. Isn't there always a catch? If you're writing that someone testified, you need to use the full name of the person spelled correctly. If you want to quote the Crown Attorney, which is the name in Canada for the state prosecutor, in the United States they call it the district attorney. If you want to quote the Crown Attorney, you need the full name of the person spelled correctly. If you want to quote the judge, if you want to quote the defense attorney, you need the full name of the person spelled correctly. If you want to quote the judge, you need the full name of the person spelled correctly. By now, you see there's a pattern emerging. You need the full name spelled correctly of those you quote. And that's not as simple as it sounds. Usually, when a witness is on the stand, unless there's a publication ban on the person's name, so you can't publish the name, the person begins his or her testimony by spelling out his or her name for the court record. And you can copy that down. Otherwise, you can't put your hand up during a trial and say, please, sir, please, Your Honor, how is that name spelled? I didn't quite hear that name. No, you can't do that during a trial. You need to get the spellings of the names, preferably before the trial starts or afterwards. So for that reason, be friendly with the court clerk sitting in front of the judge, because if you ask nicely when the trial is not in session, that person usually helps you. By now, you should be realizing that however simple journalism seems, when you read a newspaper story, reporting even what is simple can get difficult. At the end of the trial, you will be grateful that you can write extensive notes and quote accurately, that you came to the trial beforehand with names and facts, and that you have such a friendly personality that people help you when they don't have to. This lesson comes home when I take a class into the courtroom, like the one behind me. And what I've done in this course in the past is do lab exercises where I take the class into a court case, everybody takes notes, returns to the journalism lab to write a story, in some cases the same day. When we get back to the lab to write the story, everybody in the class realizes how important it is never to leave without getting full names and spellings. Some students get back to the lab and think they can find the spelling on the internet. Well, that takes valuable time, and sometimes the name isn't on the internet. And sometimes the spelling online is in error. I remember one class where I asked the students in the lab how to spell the name of the accused, and the students in the class had 3 different spellings for the accused. One class, 3 different spellings. They were all sitting in the same courtroom. Never assume on hearing a name that you know how to spell it. And that's why I take marks off in this course for misspelling a name or an organization. Now, you can record your observations of what is empirical and have witnessed without needing a citation. So if you're on the scene of an accident and you see a blue Honda SUV flipped upside down, you can write that a blue Honda SUV was flipped upside down. That's an empirical observation. You don't need a citation for that. If you are in a courtroom and the mother of the murder victim breaks down in tears during the testimony, you can write that. Of course, that means that you can identify the people in the courtroom. You don't want to write that the mother of the victim burst into tears when it was actually the mother accused. And in that case, you need the full name too with the correct spelling. If you're in the courtroom and observe an expression on the face of the accused or witness, you can write that. But be careful that you are just writing a physical observation and not attributing a mental state to someone. You don't know what someone is thinking. For example, if the accused puts his head down during part of the testimony, you could write that the accused put his head down. But not that the accused put his head down in shame or remorse or lack of sympathy. You don't know what was going on in the head of the person. You don't know what someone is thinking. Even facial expressions can be hard to interpret in tense situations. A person with a blank expression may be feeling intense emotion instead. So you could describe that someone was not showing emotion, but you couldn't interpret that as a mental state of being uncaring or callous. Some people have a blank expression when they're feeling intense emotion inside. Or people joke when they're upset or nervous to deflect the emotion. It doesn't mean they think the situation is a joke. It's just out of nervousness, that's their way of responding. Next tip, in what you write as a journalist, don't use personal pronouns that include you in the story. You are scrubbing, you have the discipline to scrub your story from your personal beliefs and your personal ideology and your personal interpretations. An easy way to do that is don't use personal pronouns. In order to be neutral, obviously you don't give your personal opinions in a story, but sometimes opinions can be embedded in the words that are used. So be careful of your words. Use neutral terms. For example, in the case of the trial of the man in Kamloops who was schizophrenic, a story in the Vancouver Sun last March used inflammatory language and called him, quote, notorious BC child killer Alan Schonborn. Now, you know, that kind of inflammatory language makes it sound as though he made a career out of being a child killer. It's that there are personal opinions in that language. It's demonizing a person who is seriously mental ill and using the rhetoric of outrage to appeal to readers who would feel that way. So be careful of your language, your word choice, that it doesn't include an interpretation. In order to be neutral, in order to be balanced and fair in the context of the story, and be careful of the context of the story and the people you choose to interview. That is, interview people from all sides of the story, including the person convicted of an offense. Now, specifically in a court case, you really will not be interviewing the accused. That would be a bad idea. Remember that once a person is charged with a crime, and until the judge has ruled, you are very limited in what you can write and who you can interview, because you don't want to prejudice the right to a fair trial of the person who is charged. So you have to be very careful about who you interview and interviewing the person charged. If the person claims to be not guilty and you write a story that seems to exonerate him before the trial ends, that could influence the jury and so prejudice the case. And the court case taking place right now, it started at 10 a.m., the same time as this this session of this class. It's a jury trial, and the justice system is particularly sensitive to anything that would prejudice a case, particularly when there's a jury trial. So, be neutral, fair, and balanced. But being neutral, fair, and balanced also means being sensible. Don't equalize sides that are actually out of proportion. Don't legitimize an obviously fringe position by making it equal. For example, in reporting about global climate change, some reporters give too much space and credence to climate deniers in an attempt to be balanced and fair. Or if you're writing a story about the Holocaust, about the extermination of Jews in Germany during the Second World War, don't give equal space and credence to Holocaust deniers in the name of fairness and balance. So when we're watching TV of what's happening in the United States, and the media are reporting on conspiracy theories and things that aren't true, you'll notice such as Donald Trump actually won the election, and that's what Donald Trump continues to say. You'll notice that every time responsible reporters tell the audience about these conspiracy theories or these lies, they will also make the point of saying factually that that is not true. There's a famous trial from a few years ago when a history professor in the United States was sued for libel in court and in Britain by a historian who was a Holocaust denier. And the lawsuit had to do with 3 paragraphs in a book written by the historian, 3 paragraphs that named this historian and called him a Holocaust denier. Now, as bizarre as it sounds, it was a hard case to win in court, very dramatic. In the end, the professor and her publisher, Penguin Books, won the libel case. And there was a great film about that called Denial, which I sometimes play in class because it helps to illustrate the difficulty of proving something in a court case. In this case, the difficulty of proving that the Holocaust happened. I know that sounds bizarre. Part of being fair and balanced is the placement of dissenting sides in the story, whether in print or broadcast. If the other side of the story is credible, summarize that side of the story at the top of the story. Don't leave it to the end. If you leave it to the bottom of the story, if you leave the dissenting side to the bottom of the story, that suggests is less important, less credible. And so that's why your skill in summarizing is important. Summarizing the whole story at the beginning, including the dissenting sides. In Canada, you can't interview jurors, and judges in Canada will usually not consent to be interviewed about a case that comes before them. Note that the text in this course is American, and the points it makes about U.S. law can be similar to Canadian law, but not always. And I teach a full course on media law in this program, and I use a Canadian media law text. One exception to that point that I just made, that you probably won't, a judge probably won't consent to be interviewed about a case that the judge ruled on. One exception is actually a story that a student in one of my journalism courses wrote about what I call the Hamburger Thief, and I mentioned last time the man with an organic brain disorder sentenced to 6 weeks in prison for ordering a hamburger in Kamloops that he couldn't pay for. The judge in this case unexpectedly returned the call to the student while the student was driving her car. She pulled to the side of the road. She did the interview by cell phone. Luckily, she had a reporter's notebook with her to take notes. You never know when an interview will happen. You always want to have your notebook and your pen. In order to be neutral and disciplined as a journalist and in your writing, ask yourself, what are the contradictions and ambiguities in the story you're writing? Writing a too simplistic version of a story may not be balanced and fair. Life is full of contradictions and ambiguities and ambivalences that don't fit a simplistic version of reality. Finally, if you have any vested interest in a side of the story, either ask that somebody else in the newsroom do the story or give full disclosure in the story, usually in a separate line at the end or at the beginning. I actually had an incident of that happening in this course one time where a student was writing a story as an assignment. It went through various drafts, and the main source in the story was someone the student was living with, and the student didn't identify that in the initial version of the story. I had to point out to the student that she needed to give full disclosure. News values. Well, what is great about writing stories about justice, about crime, courts and prison, is that news values are built in, and the system does most of the work in finding crime and accused people for you. The news values are that crime and justice has a high impact because people suffer injuries. Sometimes there's magnitude in the number of people affected by the crime rate, and then there's proximity, and the crime happens in a community or in a country. And it also has the news value of timeliness because it just happened. In addition, justice and fairness are news values as well. People are always interested in justice and fairness, even if they are not immediately affected. Our interest in justice and fairness is global. So, we're interested in what's happening in Myanmar right now, and how the citizens who are protesting the military coup are being treated. As well, there's real human drama in crime and justice cases, and that's why you see real-life crime shows on TV. And as well, we should consider human values like compassion and sensitivity, as Marie Colvin does. The text talks about that because in the crime beat, you're often talking to victims, and so sensitivity is required. I remember one student in this course telling me one time she'd done an assignment at the courthouse and had done a long interview with a victim, and the student came back and told us that she'd cried during the interview because it was so emotional. The text talks about finding stories on the public safety beat in specific locations, like the hospital, just like Marie Colvin did in conflict zones. In Canada, if you want to do interviews inside a hospital of staff or of patients, you need to get permission first from the hospital administration. In Canada, it's part of our culture here that privacy rights are valued more highly than in the U.S., and hospitals in Canada and schools as well protect the privacy of people first. Developing sources is important on the justice beat. As I said last time, you have to build trust with sources. whether official sources on the beat or unexpected sources among victims and witnesses. As part of that, the text says, if you're on a beat, like a justice beat, you should always be there, be visible among the officials, become familiar to the officials. When you are trustworthy and people get used to seeing you all the time, they talk to you more easily. Look at how much time Marie Colvin spent socializing with official sources when she wasn't writing a story. Of course, you have to be careful that you don't become so familiar to your sources that you forget you are a reporter. But still, being assigned to a beat means that you can become, the people on your beat, officials on the beat, can become familiar with you, and that's very useful in terms of news gathering. So I know that when I was on the court beat, I was in court every day, and after a while, the judges and the prosecutors and the defense attorneys got used to seeing me there, and so they were more relaxed around me and more willing to chat. You take the time to chat, just to make people familiar with you. I remember I usually came to court with reading material because you spend a lot of time sitting there and breaks and that. And I always brought the newspaper, and often lawyers would come up, I'd carry the Globe and Mail, and they'd come up and they want to read my copy of the Globe and Mail, and I'd say sure. The main point is being on a beat and allowing officials to become familiar with you is a real asset in reporting. When you're developing official sources on the beat, you should get to know the chain of command and respect how the chain of command operates. Official organizations don't like it when somebody from the media gets information by violating the chain of the command. You might get one story doing that, but it might also be the last story you're able to do on that beat. So find out who is authorized to say what. Officials are usually professional civil servants, separate from elected politicians, and they know their limitations as civil servants to what they can say. At the top of a typical civil servant department, there may be an elected official who is temporary and has a different agenda from elected officials. So in terms of the justice system in BC, there's a Solicitor General, there's an Attorney General, and they are elected positions. A final few comments. The best parts to cover in a trial are the opening arguments where the case is laid out and summarized, the testimony of key witnesses, the closing arguments, and the sentencing. The CP Style Book has 19 pages to sum up basic legal issues in court reporting. If you're intending a career in journalism, you should have a copy of the CP Style Book and CP Caps and Spelling. And I've posted some sections from the CP Style Book on Moodle for you. And just remember, as a journalist, you don't get training to cover the court system or the justice system. It's assigned to you probably when unanticipated, and you're just expected to learn on the job. Finally, how to prepare for a court case. To prepare for a court case, be careful of what you Google because it could be wrong. You want to prepare with official documents. These days, the court system has basic online information of guilty convictions and a roster, or what's called a docket of cases across BC for the day, including Kamloops. I've posted those links on Moodle for you, and I used them this morning to see what the cases were in BC Supreme Court in Kamloops. Before the case is in court, you can go to the court office and ask to see the court file in the case, which is a public document. But remember, that's before the case goes to court. Once it goes to court, that file goes into the courtroom and you can't get it. Now, this court file contains the charges and details about the accused which are useful for your story. It will also include names and spellings. You don't have to be a journalist to ask to see the court file. If you are ever refused access to the court file, don't be intimidated. Verify that it's a public document and ask why you are being refused. Take notes of the answer and request a reason why you're being refused. I remember a student of mine, in this course in the past, I've done an assignment where a student can pick any time and go down, sit in a court case in Kamloops for half a day or a day and write an assignment based on that. And one time I remember that a student of mine had been intimidated when she was trying to see the court file and being asked why she wanted to see it. She took the question to mean that she couldn't see the file, and she left, and that was incorrect. I told her that she doesn't need a reason to see the court file. It can't be refused. The question she was asked, why do you want to see it, doesn't even make legal sense. So just stand your ground, be respectful, and politely ask, aren't these files on the public record? Sometimes a part of the file may not be on the record, so you can't see it, but most of the time the court file, all the court file, is on the public record, and so you can check it out before the court case starts. And in any case, it's always good to know what kind of government documents are on the public record for everybody to see. Get to the court early to talk in the hallway to the lawyers and journalists who can help you understand what is happening. I always did that as a court reporter. I would ask lawyers what interesting cases were coming up, or what kind of testimony would be heard in his or her case today in court, or what kind of evidence would be presented today and why it would be legally important in the case. I could, by coming early, I could just ask what was going to happen in court that day. And usually, the lawyers would tell me, and then I was prepared. The lawyers know, the prosecutor and the defense know what's going to happen in a trial because it was rehearsed at the preliminary hearing, and both sides know who the witnesses are and what the witnesses will testify. I said preliminary hearing. What does that mean? In Canada, a preliminary hearing comes before a criminal trial to decide if there's enough evidence to proceed to trial. The defense will usually ask that the trial not proceed. The judge usually decides that the case will proceed to trial. But a preliminary hearing is under a complete publication ban because evidence in the preliminary hearing may not be admitted during the trial. Thus, if evidence is published in the preliminary hearing that does not appear in the trial, that could prejudice the case. As a court reporter, I used to attend preliminary hearings and take notes, even though I could not publish those details before the case was tried. The reason I attended the preliminary hearing was because I got information about the case that helped me understand what was going to happen in the trial. Just before I left my newspaper job to teach journalism here, I attended the preliminary hearing of a murder trial where a woman had been charged with scalping her son with scissors. I remember that, believe me. During a break in the preliminary hearing, I chatted in the court cafeteria with a key prosecution witness, a famous child forensic scientist. After I left to take this job, the mother was tried, convicted, and sentenced to prison. Years later, I read that she was found wrongfully convicted based on faulty evidence of the child forensic scientist that I chatted with. That meant that all the cases where the same expert witness had been used to convict people were now in doubt, and there were hundreds of court cases. So the prosecution, the defense attorney have been through the preliminary hearing. They know the list of witnesses on each side. They know what the witnesses will say, and they know what evidence will be produced in the trial. They may even go into court thinking they will lose the case. But you never know what will happen in a trial. Maybe a witness will crumble under cross-examination or retract what the witness has said before. Maybe the jury will be deadlocked. Maybe the jury will be unpredictable. Maybe the judge will not admit some evidence and rule on technicality. You never know. Let me end by saying that court cases are a good place to start as a journalist, even as a freelancer. You can keep your eyes open for an opportunity. Maybe someone is on trial in Kamloops from a distant location, and an editor from that distant location would rather you cover the story freelance than paying for the cost of sending a reporter to Kamloops. And you might even try sitting through some cases in Kamloops in the courtrooms here just to get familiar with it.